Ready, start. The incident is of 23rd June, 1992, full stop. The order of conviction by the trial court has been affirmed by the impugned judgment of the High Court, full stop. We may note here that this court, by the order dated 9th July, 2012, enlarged the appellants on bail by noting that they have already undergone incarceration for a period of about 8 years, full stop. As the advocate on record of the appellants was elevated as a judge of a high court, notice for making alternative arrangement was issued to both the appellants, full stop. Notice was served to the second appellant, but could not be served to the first appellant for want of complete address, full stop. Therefore, the appeal as far as the first appellant is concerned has been dismissed for non-prosecution, full stop. This being an appeal against conviction, the case of the first appellant on merits has to be examined, full stop. Therefore, the order dismissing the appeal qua appellant number 1 is recalled, full stop. We requested the learned counsel appearing for the second appellant to assist us for dealing with the appeal of the first appellant, full stop. He has readily agreed, full stop. PW-2 Sukhi and PW-3 Ratan Singh are the only two alleged eyewitnesses, full stop. As far as PW-3 is concerned, he did not support the prosecution and therefore, he was declared as hostile, full stop. So far as the version of PW-2, who is the first informant, is concerned, he stated that he along with the deceased had gone to a place known as Chensa, full stop. On the return journey, they got down from the bus at Mohna, full stop. The incident occurred around 8 to 8:30 p.m., when they were near a tube bell, full stop. According to him, four persons emerged out of bushes, full stop. One of them abused the deceased, full stop. The first appellant fired a shot at the deceased, full stop. The appellants dragged the deceased towards the field on the left side and thereafter, fired two shots, full stop. The witness further stated that he cannot tell the name of the persons who had fired shot at the deceased, full stop. Assuming that PW-2 really knew the appellants before the incident and he had seen the appellants while firing shots at the deceased, we find that PW-2 did not identify the accused who were present in the court as the accused who killed the deceased, full stop. In fact, the examination in chief of the PW-2 shows that the witness has not identified the accused who were present in the court, as there is no such statement in the examination in chief, full stop. A witness who claims to be an eyewitness must be in a position to identify the accused in the court, full stop, with a view to ascertain whether an actual P-4 is the correct reproduction of the deposition of PW-2. We have perused the original deposition of PW-2 from the record of the trial court, and we find that even the original deposition does not record that the PW-2 identified the accused in the court, full stop. Assuming that PW-2 had seen the appellants firing shots at the deceased, unless the said eyewitness identifies the accused as Dharma and Prakash, the prosecution cannot establish that the accused who were prosecuted were guilty of the offence, full stop. As stated earlier, the only PW-3 was declared as hostile, full stop. Therefore, this is a case where the eyewitness has not identified both the accused in the court, full stop. In the circumstances, the appellants could not have been convicted in the absence of their identification by the eyewitness before the court, full stop. Hence, the appeal is allowed, full stop. The impugned judgment dated 30th May, 2008, passed by the division bench of the High Court, and dated 23rd October, 1998, passed by the Sessions Judge, Faridabad, Haryana, are hereby quashed, full stop.